Ready? Assalamualaikum and hello everyone. I'm Muhammad Alamin from Malaysia Productivity Corporation. I think we get to started my introduction here. We had about 151 participants registered for the webinar, and hopefully more people to join in the next few minutes. Welcome to GRP Webinar Series on the topic of Understanding Malaysia Regulations, Part 1, organized by MPC. This GRP Webinar Series is a platform where we bring experts to share information and best practices regarding good regulatory practice. It covers various topics to help policymakers, regulators, businesses, academia, and interested parties to enhance knowledge on how to improve the quality of regulation without slowing economic growth, innovation, competitiveness, and job creation. Government mainly have, which is number one is to collect money through taxes. Second one is spending money for development, infrastructures, and public goods. And third one, to regulate, to protect safety, health, environment, welfare, and public goods. Thus, understanding Malaysia's legal system is a fundamental for those who are interested to improve the quality of regulation. Today's topic is about understanding Malaysian regulation. The main objective of these sessions is to provide an overview of the Malaysian legal system and the lawmaking process of regulation, and as a refresher for those who already know about regulation. We divided into two parts, where part one, we talk about focusing on the Malaysian legal system and fundamentals on primary and subsidiary regulation. And part two, which is next week, will be more focused on legislative process and common features of regulations. I would like to welcome our speakers today, Ms. Lia Safura Abdul Rashid and Ms. Nik Shafiqah Ibrahim from Zahid Ibrahim, which is a law firm. Lia Safura is a senior associate in the corporate and government advisory practice group at ZICO, a member of ZICO Law. She admitted to the bar in 2014 and thereafter was awarded with the prestigious Chevening Scholarship by the UK High Commission to pursue her master's degrees at the Queen Mary University of London. Lia has been building her capability in law reform by advising select federal ministries and government agencies in regulatory mapping and conducting feasible studies in relation to the review of primary and subsidiary legislation, which is involved, among others, conducting key stakeholders engagements and proposing policy recommendations. On the law reform, she advised on matters relating to compliance and governance, in particular, advising GLCs and statutory bodies on board roles and responsibility reporting, as well as assisting clients to develop compliance programs and processes, including the drafting of various corporate documentation, such as constitutions, guidelines, standards, operating procedures, and TOR to name a few. Today, Lia has co-authored articles relating to the sharing economy, which has been published by Praxis, the Malaysian Bar publication, as well as contributed in Islamic Finance academic textbooks and written in the Malaysia Islamic Finance Report by Thomson Reuters. Outside of the office, Lia is actively involved in civil societies addressing current issues relating to ethics and governance in Malaysia. Shafiqah, senior associate in the corporate and government advisory practice group at Zahid Ibrahim & Co., a member of ZICO Law. She graduated from University Technology Mara in 2017 and was admitted to the bar in 2018 as an advocate and solicitor of the High Court of Malaya. She has been actively involved in advising the federal government and state government, including various ministries, agencies, and statutory bodies on law reform, in particular on conducting regulatory impact analysis and preparing regulatory impact statements. She also has advised on regulatory mapping, feasibility studies, on reducing regulatory burden as well as deregulation of law. She also specialized in providing legal advisory services for startup and small and medium enterprise. Realizing the importance of digital technology, she has collaborated with ShakeUp, an online legal platform, to provide legal and professional services online. In addition, as a founding member of Zico Labs, which is Zico Law's regional CSR to support the startup scale-up ecosystem, she has conducted training and awareness sessions on various legal matters, ranging from legal clinics to panel sessions in assisting these organizations. At the same time, she also worked with regulators, accelerators such as MDEC to supercharge the growth of Malaysia's startup ecosystem. During the webinar, participants are invited to send questions via the question box. So please, if you have any questions and clarification, send it to the question box. The speaker at the end of presentation will address some of the questions received. We may not have the time to discuss all of them, but I will group or select some of the questions to represent some of your questions. This webinar is being recorded and will publish in our website when ready within the next few days. So with that, I would like to invite Nick Shafika to do his presentation. Please, Nick Shafika, thank you.
All right, many thanks, Encik Alamin. Hi, my name is Nick Shafika. So just now I asked Encik Alamin, so kita nak serious ke informal? And then he said, kita serious, but then relax. So don't be scared. I know we're talking about regulations today. We're wearing blazers, but actually kat bawah kita tengah pakai shorts. So boleh je kalau korang nak makan kat belakang tu. We'll try to make this as entertaining but informative. Okay. So for this particular seminar, we'll be discussing on Malaysian regulations, but just the general overview. Next, please. So next, please. So for the outline, first we will be discussing on federal constitution, and then we will be discussing on the legislative, executive, and the judicial authority. And lastly, we'll be discussing on the legislation. So we will explain the definition and also the scope of each of these regulations. All right. Okay, so first is the federal constitution. So what is the federal constitution? So federal constitution is actually the supreme law of the federation. If you look at Article 4, jangan takut, Article 4, subsection 1 of the federal constitution, it states that this constitution is the supreme law of the federation, and any law passed after Merdeka Day which is inconsistent with this constitution shall, to the extent of the inconsistency, be void. So this particular act is the main act, dia macam ibu act in Malaysia. So all laws passed in Malaysia, it has to be in line with federal constitution. So if it's against the federal constitution, then it will be considered as unconstitutional. And Article 32, subsection 1 states that there shall be a supreme head of the federation, and he shall be called the Yang di-Pertuan Agong. He's the head of all of the bodies in Malaysia. So for the federal constitution, under federal constitution, there's for the government in Malaysia, there's 3 types of government bodies. First is legislative, second is executive, and third is judiciary. So if you want to look into this further, you can refer to the relevant subsection I've listed under this. So just in a nutshell, legislative mean what they do is that they legislate the law, meaning that they actually make the law. Executive is they execute the law, and judiciary is all the courts whereby they will implement the law. Okay. So first I'll be discussing on the legislative authority. So who's inside legislative authority? So legislative authority of the federation shall be vested in the parliament. So parliament consists of Yang di-Pertuan Agong, Dewan Negara, and also Dewan Rakyat. So for Yang di-Pertuan Agong, as you all know, every 5 years there will be rotation out of the 9 rulers in Malaysia. For Dewan Negara pula is the all of the representative that we have elected during general election. And for sorry, that's Dewan Rakyat. Dewan Negara is the senators appointed by YDPA. Okay. So legislative body, the power is to legislate, pass, amend, or repeal federal laws, matters under the federal list. So the power is determined under the federal constitution. So for federal laws, it is made by the parliament, but for state laws, it is made by the legislature of the state, which is the state legislature. So for the process, there's two steps. First is the pre-parliamentary stage, and second is the parliamentary stage. So for pre-parliamentary stage, before any ministers want to make any laws, they will have a government proposal, like internal government proposal, whereby, okay, they decide that, oh, maybe we should have a particular act on this particular topic. And after that, they have to conduct a regulatory impact analysis. So based on the national policy on the development and implementation of regulation, it states that before you actually amend or create new law, you have to undergo regulatory impact analysis, whereby you have to explain why do you need this law, and you have to conduct public consultation and conduct cost-benefit analysis to explain in detail as to the reason why we should introduce a new regulations. And after that, they will be meeting relevant government authorities to discuss further on the need to have the laws. And after that, they will draft the bill. The bill is, before you pass a law, you have to draft the bill first. So the bill normally is drafted internally by the respective ministries, but after that, they will pass it to the AG, Attorney General. And Cabinet will have to approve the bill before it becomes an act. So that is before they masuk parliament. So during the parliamentary stage, we can refer to the next slide. So there's 7 steps. So first, once the draft bill is ready, they will bring it to Dewan Rakyat, whereby they will have the first reading. At this point, they will just read the title. And then after that, they will have the second reading, where they will lay down the principles of the laws. And if it is approved by a majority of the members, it will be passed to the committee stage, whereby they will deliberate further, and it will be passed to the Dewan Rakyat again for the third reading, whereby they have to approve the particular bill. When it has been approved by Dewan Rakyat, it will be brought to Dewan Negara, whereby they will go through all of the same process again: first reading, second reading, committee stage, and the third reading. So once Dewan Negara has already approved that, they will pass it back to Dewan Rakyat, and Dewan Rakyat will pass it to YDPA. So all laws in Malaysia has to be assented by the YDPA. He has to assent on it. Macam cap mohor. So within 30 days after the bill has been passed, he has to assent on it, and then after that baru dia akan publicize it. So like I mentioned earlier, the parliament will only draft legislations for the federal state and also all the states in Malaysia, but then there's 2 lists in Malaysia, which is the federal list and the state list. So federal list ni, so that meaning the parliament gets to draft all of the laws with respect to any matters enumerated in the federal list or the concurrent list. And for the state pula, the legislature of a state may make laws with respect to any matters enumerated in the state list or the concurrent list. So for this particular, the relationship between the federation and the state, for federal list ni, parliament, they can only make laws yang ada dalam federal list, whereby the state legislature, they can only make the regulations and laws stated under the state list. But there's also some overlap, whereby one of them can make it, either or. That is stated under Article 74 of the Federal Constitution. So let's take a look at the list itself. On the next slide. Okay, so for federal list, it consists of external affairs, defense of the federation, internal security, civil law, criminal law, and all of this. So for criminal law, memang federal law je can actually make the law and amend or repeal the law. State memang tak boleh buat any laws relating to criminal law. So for example, the state pula, they can make all of the laws in relation to state government, Islamic law, Malay custom, Islam, local government. So this is fun fact. Okay lah, tak fun pun, it's a fact. Islamic law, for example, dekat Sharia court, so setiap state in Malaysia has their own Sharia court and also has their own act pertaining to Islamic law. So katalah Kelantan ke Terengganu ke, all of these states, they have their own laws pertaining to Islamic law. For concurrent list ni, either or can do it. However, the state too must ensure that it is in line with the federal constitution. So if it is not in line, then it will be unconstitutional. So apa-apa pun kalau ada macam bercanggah, the federal one will be more powerful lah. So yang state tu macam terbatal. That is for the West of Malaysia. And for Sabah and Sarawak, they have a supplement to state list for states of Sabah and Sarawak. It includes native law and customs. So because in Sabah and Sarawak, it's a bit special. They have like their own native law, they have their own law. So in that sense, they get to make their own laws. Same goes with the next list, which is the supplement to concurrent list for states of Sabah and Sarawak, which is the same thing as the federal punya concurrent list, whereby either or can do it. So that is for legislative, whereby they have the power to make the law, amend the law, or repeal the law. So who will execute it? It will be the executive authority. So it consists of YDPA as the head. Actually, YDPA is the head of all three bodies, and also the Malaysian cabinet. My dad is like so excited. I think he's watching this. So hi, Daddy. He actually like cut this for me. So this is the new Malaysian cabinet. Okay. So moving on. What is the executive body? So executive body is the body that actually execute the law. So it is led by the Prime Minister, who is appointed by YDPA. And Prime Minister, as you all know, leads the government because his party holds the majority in Parliament. So although the executive power is vested with the YDPA is required to act based on the advice of the cabinet of the ministers or the advice of the minister empowered by the cabinet. So usually the Prime Minister will advise him and he will act upon it. So that's why usually kalau macam every few days now we see okay, we will see like our Prime Minister on news and he will say just stay at home. But really stay at home, okay? Okay, that's with the executive authority. Now we're moving forward to the judicial authority. So judicial authority consists of the judiciary. Judiciary ni is all of the courts in Malaysia. So kita dah ada orang buat law, kita dah ada orang actually execute the law. So kalau ada salah, where do we go? So we go to the judicial authority. So based on Article 121 of the Federal Constitution, it states that there shall be 2 high courts of the coordinate jurisdiction, being the High Court of Malaya and also High Court of Sabah and Sarawak. And such inferior courts as may be provided by federal law. So this is the hierarchy of courts. So first yang paling tinggi is the Federal Court. Second is the Court of Appeal. And third is High Court of Malaya and Sabah and Sarawak. So High Court and Sabah and Sarawak are different. So for example, I'm a lawyer admitted in the High Court of Malaya, but I can't practice in High Court of Sabah and Sarawak, meaning that I can't go to their court and actually represent my client because it's separate jurisdiction. So this is considered the superior court, Federal Court, Court of Appeal, and High Court of Malaya. But then kat bawah tu, it's their Session Court, Magistrates Court, and also Penghulu Court. So Sessions Court, Magistrates Court, and Penghulu Court ni, they are called subordinate courts because they're under the superior court. So apa-apa decision made by the Federal Court, court that is higher than them, then they are bound by it. So right now I will explain on the power of each of the courts. So we'll start with the superior court itself. So for federal court, they have 4 main jurisdictions. First is the original jurisdiction. Original meaning that they have the power to hear the case for the first time. So for federal court, it's located in Putrajaya, but it's only for the original jurisdiction is any matters in relation to federal constitution. Firstly, like if you feel that a law is against the federal constitution, so we go to the federal court. And secondly, if there's a dispute between the federal and also the state, so we go to federal court to solve that. And the second jurisdiction is the appellate jurisdiction. Appellate meaning that they have the power to hear the appeal. So like I've said earlier, Malaysia is based on the hierarchy system, kan? So they get to hear the appeal from the Court of Appeal and High Court. So from High Court, if the orang dekat situ tak puas hati, they will appeal to the Court of Appeal, and then after that, kalau tak puas hati juga, we go to federal court. So that is appellate jurisdiction. And third is referral jurisdiction. Referral is just they are point of reference. So kalau Court of Appeal of High Court nak interpret certain laws, probably federal constitution, they will go to federal court. And same goes for advisory jurisdiction, whereby for this one, in particular, if YDPA has any question in relation to federal constitution, he will go to the federal court to interpret the laws. So the second one is Court of Appeal. So under Court of Appeal, their power is just dah nama pun appeal. So the power memang appellate jurisdiction je. So they will hear and determine appeals from any judgment or order of any high court. So from high court, kalau orang tak puas hati, they will go to Court of Appeal. And if tak puas, like I said earlier, if tak puas hati, you can go to federal court. And then from high court, okay, that's my picture saja je nak letak di sendiri. So their first power is their original jurisdiction. In practice, dia boleh dengar any case, but in practice, they will only determine case where the amount involved exceeds 250,000. That is for civil matter. But for criminal matters, they will only try matters that is punishable with death and very serious offences, like it must be grave. Then baru you pergi dekat high court. If not, you just go to the subordinate courts. So for their appellate jurisdiction, they get to hear the appeal from the sessions court and also magistrate court. And for the revisionary and supervisory jurisdiction, it means that they can also actually supervise and revise the decision made by the sessions court and also the magistrates court. Okay, so for sessions court, if you have any questions, you can just post on the right-hand side on the chat column. Okay, so for sessions court, their original jurisdiction is to hear and determine matters concerning motor vehicles, accident, landlords, tenants, and distress. But for other civil matters, the amount of value should be less than 250,000. So if it's above 250,000, you go straight to high court. But if it's below, then you go to sessions court. But for criminal matters, they get to try all. And they also have supervisory jurisdiction, whereby they can supervise the magistrates court. At any time, they can just check balik the decisions made by the magistrates court and see whether it's in line with the laws. And then under sessions court, there's magistrates court. So for normal people, they will just go to magistrates court, because for civil matters, any amount in dispute value of the subject matter that does not exceed 25,000, you can just go to magistrates court. And for criminal matters, they can go to magistrates court in relation to all offences punishable with imprisonment or with a fine only. But if death, you go to high court. And then appellate jurisdiction, they actually have the power to hear the appeal from the penghulu court. Tapi penghulu court ni zaman dulu lah, sekarang actually dah abolish. So last time in West Malaysia, kita ada penghulu court. So original jurisdiction dia limited to proceedings which all the parties are person of an Asian race and who speaks and understands the Malay language. So untuk civil matter, plaintiff boleh seek to recover a debt of not exceeding RM50 je. But for criminal matters, for minor offences which can be adequately punished by a fine not more than RM25. So dah tak ada lah sekarang, but then that's the Malaysian punya hierarchy system. Maybe ada certain tempat ada. Okay, so that's the main court in federal. We also have state courts and also like courts of special jurisdiction. Dekat federal level juga, we also have two special courts. It's called special court and also court for children. Special court ni is for YDPA and all of the rulers in Malaysia, semua raja-raja. So if they've committed like an offence based on their personal capacity, they cannot go to macam high court ke federal court. So they will have to go to courts of special jurisdiction, which is called the special court made specially for YDPA and also the rulers in Malaysia. And secondly is court for children. Court for children is for orang below 18 years old. So they don't have to go to normal court because under the law, you attain the age of majority at 18. So below that, you're considered a child lagi. So you need a proper environment lah. So kalau pergi court of children ni, it's private, meaning that reporters semua unknown people cannot go in the court, and then they get to invite their parents, and the judge will actually interview the parents to tanya pasal anak dia, like, oh, anak you baik tak semua. So they're more lenient in that way. So if, because yelah, for judge pun dia tak sampai hati nak punish the child, tapi kalau the kesalahan is very grave, they will send them, dia tak masuk prison, but they actually masuk a Henry Gurney school. But if not, kalau setakat macam mencuri, benda kecil-kecil macam tu, they will just macam dalam probation. So another court is the state court, like I've mentioned earlier. Dekat Malaysia ni, kalau under the state list kan, for example, the Sharia matters, macam Islamic law tadi, setiap negara dekat Malaysia have their own law. So, if you commit an offence dekat Melaka, so it's under the Melaka law, so pergi dekat Sharia court dekat Melaka. But this is only in relation to matters under Islamic law lah. And then, so for my side juga, if I want to practice or do Sharia law, then I have to take the exam in federal territories. So if I have the certificate, I can only practice in federal territories. I can't go to Terengganu ke Kelantan ke because they have their own law. So if I want to practice in Terengganu, I have to go to Terengganu and take the exam again. If I want to practice in Kelantan, I have to go to Kelantan and take the exam there. And secondly is the native court. This one is in Sabah and Sarawak because they orang ada all the natives, so they are very special. They have their own native court because they have their own customary laws yang kita pun tak tahu. Right. So that's with the power of the authorities in Malaysia. Now I will explain on legislation. So what is legislation? So selalu orang ada confused about this. So legislation is terbagi kepada dua, which is the primary legislations and also the subsidiary legislations. Primary legislation is the main act. So for this one, I will only be discussing on the federal context. So what is the primary legislations? So primary legislation is an act passed by the parliament. Parliament yang tadi I mentioned earlier, so they will actually draft the law, so they will pass it. So the main act is called the primary legislation. So the authority that can do that is Parliament. So as an example, Malaysia Productivity Corporation Act to incorporate MPC itself, that is an act passed by the Parliament. So for subsidiary legislation pula, it's more like to supplement the primary legislations, because primary legislation we only explain the broad principles, but the detailed principles will be explained in the regulation itself, which is called the subsidiary legislation. So subsidiary legislations is the laws made under an act. So the person who gets to do it is the minister in charge or any other relevant authorities or bodies under the primary legislations. Example is Malaysia Productivity Corporation Conduct and Discipline Rules 1998. So yang main act is MPC Act itself, but then under MPC Act, dia ada anak dia, which is Malaysia Productivity Corporation Conduct and Discipline Rules, whereby they will explain in detail about the conduct and discipline of the officers dekat dalam tu. But under the Interpretation Act, subsidiary legislation ni, it means proclamation, rule, regulation, order, notification, bylaws, or other instrument made under any act, enactment, ordinance, or other lawful authority and having legislative effect. So, you may ask, tak pernah tanya diri sendiri, oh, apa tu act, enactment, and ordinance? Apa beza dia? So, act is made by Parliament at the federal level. So, Parliament yang akan buat the federal law, so it's called an act. But before 1959, it is called ordinance. So, after that, we call them acts. And then tapi dekat state, for example, dekat Kelantan, they will call it enactment instead of act. but I will explain further later. And then ordinance pula, another term that is used by this Sarawak punya Legislative Assembly, whereby they will call their main act ordinance. But for subsidiary legislation, it does not include terms of reference, standard operating procedures, manual, administrative documents, charter, contracts, constitution, because that's like personal contract of the respective agencies or macam company. Your company maybe ada like your own contract, so that is not considered as subsidiary legislation. That is just macam a supplement punya law, tapi dia tak ada that power. Okay, so I will explain here. Okay, so firstly, if you look on the right, so Parliament will actually, for this for federal, yeah, they will pass the primary legislation being the Prevention and Control of Infectious Disease Act 1988, which is Act 342 as the primary legislation, because sekarang kan kita under MCO, so it's under this act lah, so it's under the Ministry of Health. So this act dah lama dah ada in 1988. So it will give power to the minister in charge or any other relevant authorities bodies to make subsidiary legislation, being for MCO in particular is the Prevention and Control of Diseases Measures Within the Infected Local Areas Regulation 2020. So all this while, like all of the things that we see online, apa yang PM announce, semua tu dah gazetted and memang ada law. So they are made under pursuant to this act, primary legislation. But they call it dia macam anak dia, so regulation. So primary act ni kena ada satu je, but dia punya subsidiary regulation memang there's it's unlimited lah. So the person who gets to draft it is minister in charge. So kalau if you want to draft an act, it will take a really long time because you have to go to parliament and undergo like the process I mentioned earlier. But regulations ni, it won't take as long. Okay. So just want to show you for the next slide. Okay, this is a sample of the Prevention and Control of Infectious Disease Act 1988, which being the primary act. If you look dekat section bawah-bawah, usually there will be a clause to say power to make regulations. So if you click on it, the power to make regulation, it will say that the minister may make regulations. So the act itself memang dah bagi the power to the minister to actually make the regulations. So that's why cepat je. Okay, that is for the federal law. And then moving forward to the state punya law that I've mentioned earlier, primary legislations is called enactment or ordinance. Enactment is all of the states in Malaysia. Kalau the state make their own laws, except for Sarawak. Sarawak, they call it ordinance. And it is made by the State Legislative Assembly, being the DUN lah, Dewan Undangan Negeri. So for example, in Kelantan, they have the River and Drainage Enactment. So for subsidiary legislation, it's laws made under the enactment and ordinance. So sama je lah macam principle tadi. But the authority that will get to do it is ruler in council or any other relevant state authorities or bodies. So example, for tadi river drainage and drainage enactment, so bawah dia, they have like river and drainage rules. So that's it from me. My colleague will take over from here, but if you have any questions, feel free to ask. Thank you.
Okay, Bismillahirrahmanirrahim. Rabbi Syahli, Sari Wayasili, Amri Wahdumundatani, Sadiyaf Kaukawli. Assalamualaikum and hi everyone. Sorry, first and foremost, before I start, I just want to say that I'm very happy to be here and thank you so much for attending our talk. And for now, and also thank you, Nick, for laying out the foundations in relation to Malaysian legal system, as well as the definition on primary and subsidiary legislations. I understand that moving on, I'll be speaking on the scope of primary and subsidiary legislations, as well as a few other principles under this topic. And I just want to say that some of the things that I'll be presenting might overlap with what Nick has presented before, but I felt like those points are very important and it should be recapped and reiterated throughout this presentation. So moving on, let's just take a look at the varying types of primary legislations that we have. So if you look into the blue boxes here, we have three types of primary legislations, as Nick has explained before. We have Act, enactment, and ordinances. So how do we actually vary and identify and differentiate the varying types of primary legislations? So the way to do it is to actually to look into the scope as well as the legislative authority that are allowed and empowered to actually make these laws. So let's take a look at what we can see from this slide. So for the scope of Act, we can see that these are federal laws enacted by the Parliament, and respectively, the legislative authority is the Parliament itself. So for enactment, as Nick has mentioned as well before, they're basically state laws passed by state authority. And the legislative authority would be the state legislative assemblies, and except for the state of Sarawak. And the reason why I have to highlight that it is except for the state of Sarawak is because the primary legislations for Sarawak are only called ordinances. In contrast, for Sabah, the primary legislations are called both enactments and ordinances. So that relates to the third category of primary legislation, which is the ordinance. So ordinances could be laws for Sabah and Sarawak, or it could be laws enacted by the federal legislature between 1st April 1946 and 10 September 1959. So this is basically all of your pre-Merdeka laws, or ordinances could also be laws promulgated by the YDPA during an emergency. So who is the legislative authority for the ordinances? Respectively, as I mentioned, there are state legislative assemblies of both Sabah and Sarawak, and the federal legislature between 1946 and 1953, as well as YDPA by virtue of Article 150 of the Federal Constitution. So now that we understand the varying types of primary legislation, I would just like to zoom into the acts and the types of acts that we have. If we go into the next slide, please. So the next slide, I think I jumped the gun for a bit. So basically, these are some of the examples in relation to primary legislation. So for Act, we have the typical Companies Act, which everyone is very familiar with, and the Dangerous Drugs Act 1952, as well as the Married Women and Children Maintenance Act 1950. For enactment, like I said, these are generally primary legislations for states. So we have here the Kedah Water Resources Enactment 2008, Wakaf State of Sabah Enactment 2018. As you can see, Sabah actually has laws that uses the title enactment, as well as the State Public Service Commission Enactment 1991. So what do we have for ordinance? Moving on. So we have Emergency Public Order and Prevention of Crime Ordinance 1969. And then we can see that we have Sabah Land Ordinance, Cap 68, Sarawak River Ordinance 1993, and Carrying of Arms Ordinance 1947, which was made before the Merdeka was granted to us, I suppose. So and moving on. Yeah, so like I mentioned just now, we just like to zoom into the varying types of acts that we have. So we have 4 types of varying acts, namely the first one is the Principal Act, second is the Amendment Act, the third is the Revised Act, and the fourth is the Consolidated Act. So what does this even mean? So Principal Act is the most common type of primary legislation that we have. For example, it's the Companies Act 2016. An Amendment Act, it makes changes to the Principal Act, and it should also go through the Parliament if you actually want to make any amendments to the Primary Act. So here we actually have, so Companies Act has been amended, and the Amendment Act was Companies Amendment Act 2019. So the third one is the Revised Act, and this results from changes limited to only typographical, grammatical, or like things that doesn't actually affect the substance of the legislation itself. Then if you actually have like a number of typos, instead of making amendments, you'll just publish a new one, which is called the Revised Act. And the fourth one and the last one, we have Consolidated Act, which brings 2 or more acts on a specific subject matter, which had been passed over a period of time. So the example that we use here is the Interpretations Act 1948 and 1967. So these are consolidated primary legislations in relation to Interpretation Act. And also, I'd just like to highlight that Interpretation Act is very, very fundamental in trying to scope out the scope of primary and subsidiary legislations, because all of the interpretations are included under the provisions under the Interpretation Act. That is a side fact, but let's move on to some of the examples that we have for all of this. So for primary legislation, the Principal and Amendment Act, we did a bit of a check on the depository, on the numbers of Principal Acts and Amendment Acts that we have in Malaysia. So as we can see, if you look into the AG, chambers actually have a portal where you can look into all of the laws in Malaysia, in particular only for the primary legislation. So if you look into the website, at the end of it, you can see that we have 821 Principal Acts in Malaysia, and these are all acts that are already enforced. So there are also acts that have yet to be enforced, but those are the ones that we don't actually include in the number of Principal Acts in Malaysia. So for number of Amendment Acts pula, I put here not available, not because we don't have any. Of course, we have plenty of Amendment Acts in Malaysia, especially considering that legislations are meant to be reviewed from time to time, ideally every 5 years. The reason why we can't really ascertain the number of Amendment Acts is because it's really difficult, and you actually have to go through. So the AG Chambers website wouldn't actually have the breakdown of those things. So you need to look into certain search engine and look into the primary legislation, and then you look into the Amendment Act. So for me to actually find out the numbers, it will be very, very difficult. But maybe if anyone has the answer, I would like to know. If you can post it in the question box, I'll be very interested to learn about the number of Amendment Acts that we have in Malaysia. So if we move on to the next slide as well, we will be looking into the Revised and Consolidated Act. So the number of revised acts that we have in Malaysia are 28. So these are some of the examples that we have, which is the Statutory Declaration Act that was revised, as well as the Pool Betting Act 1967 that was revised. For number of consolidated acts, we only have one, which is the Interpretation Act 1948 and 1967. Okay, everyone should bear with me. We're trying to change the slides. Yeah. So now that we have covered the primary legislation, let's take a look at the subsidiary legislations. So for subsidiary legislations, if you can remember how I presented on the primary legislation, we could see like there are varying legislative authority for the different types of primary legislations. But for subsidiary legislations, it is the same as well. But because I think I will explain this a little bit more in detail in 1 minute, but let me just take a look at the legislative authority. So because subsidiary legislations are made through powers delegated by the legislature to a body of persons via an enabling or parent statute. So what this means is once the primary legislation has been passed in the parliament, it has a provision that gives the power to an implementing agency, typically maybe certain department or government agencies in the federal ministries, to implement the provisions under that particular act. And because they have the power as an implementing agency, it should be that under each of the under each of the primary legislations, you will be able to take a look at the provisions where such implementation authority would have the power to make subsidiary legislation. So it could be passed by a minister, it could be passed by government agencies, etc., etc. So why do we actually need subsidiary legislation? So the general rationale why we need subsidiary legislation is the fact that the Principal Acts are typically intended to cover general principles of the law only. And that is because the general principles of the law would regulate certain activities, but in relation to the nitty-gritty and the details of, for example, if you look into Tourism Industry Act, we have a provision where if you want to carry out activities relating to tourism, you have to be registered and licensed by the Ministry of Tourism, Arts and Culture. So, but the procedures and the nitty-gritty details in relation to the application for the license or the requirement for the licenses are all stipulated either in the regulations or in their guidelines. So generally, this is why we need subsidiary legislation as an act to supplement the primary legislation so that it's easier for people to have better clarity, and most importantly, because it is very difficult to pass amendments to the primary legislation, because you have to go through the parliament, you have to get royal assent and stuff like that. So that is why it's easier for you to just pass the subsidiary legislations if you need to regulate certain activities and provide more details on the provisions under the primary legislations. So because the implementing agency now have a lot of power to pass their own laws, we do have controls over subsidiary legislations. Namely, we have judicial control, legislative control, as well as consultation. So let me just take a look at the first one, will be the judicial control. Is basically where the court has the power for judicial review. What do we mean by this, right? So judicial control is where sometimes, due to maybe lack of clarity in the law, there could be times where implementing agencies might conduct themselves in an ultra-virus manner, meaning to say that they don't have a power, for example, to impose certain fees, but they still impose certain fees by passing through a subsidiary legislation. So when that happens, the public can actually contest and go to the court and contest on the number one, applicability of the provision, since it is not within the scope of the primary legislation. And secondly, it could also be that the subject matter is unconstitutional. So if it's unconstitutional, that is also a matter that is up for judicial review. So other than judicial review, which is for me is one of the most fundamental and important control that we have in trying to make sure that subsidiary legislation fulfill the full intention of the primary legislations, we also have legislative control. So what do we mean by legislative control? So the delegated powers by an enabling statute may be repealed or varied by the parliament. How can they do this particular thing, right? If we say that the legislative authority for subsidiary legislations are the implementation authorities, so how do we actually how would the parliament have a power? So a way for the parliament to ensure that they still have control over subsidiary legislation is by way of including laying provisions. So what are laying provisions? Laying provisions are generally provisions which require the subsidiary legislations before it can be passed effectively as a law. It is required for it to be tabled in the parliament and passed by the parliament as well. So that is a way for we to have legislative control over subsidiary legislations. And the third one is something that I really like doing, which is consultation. So previously, prior to that year 2013, consultation for subsidiary legislations are only made based on ad hoc basis, and this is something that will be determined by the implementation authority. But now that we have the circular number 1 in 2013, it was issued by the Secretary General back then. Every new legislation or legislation related to businesses, investment, and trade to be amended must undergo regulatory impact analysis. So regulatory impact analysis, one of the most core principle in relation to regulatory impact analysis is public consultation. So I know this is a bit of a shameless plug, but I just want to say that this series will also include a talk on public consultation and general principles in relating to RIA. And I think this is it's going to be very, very interesting. So if you are interested, please stay on and try to register for the session. And as you can see, we actually have 151 attendees here, and it's already maxed. I understand that a lot more people are trying to come in. So try to register early as soon as MCC started distributing the link, and then I will see you then again. But coming back to this presentation, we'll go into the next slide. So here we have 7 types of subsidiary legislations that we can find, and the reason why we have number 1 to 6 and we have 7 as others is because these are the types of subsidiary legislations that are included under the definition of subsidiary legislations under the Interpretation Act. So the Interpretation Act includes subsidiary legislation to be 1, regulation, 2nd, rule, 3rd is order, 4 is bylaw, 5th is notification, 6 is proclamation, and 7 would be the varying types of statutory legislation that we have. So let's take a look at some of the examples that we have for all of these varying types of statutory legislation. So for the first one would be the regulation. So what is the scope? So this is how do you differentiate again the varying types of statutory legislation. We typically look into the scope and the language and the substance of that particular regulation as statutory legislations. In particular, we would look into the intention of the statutory legislation, and then we can differentiate them from one another. So if we look into regulation, regulations are generally impositions of regulations by government, backed by the use of penalties that are intended specifically to oversee social and economic behavior of the public. So I also just want to highlight that all of this scope that we have and definition that we have in relation to the varying types of statutory legislations are general understanding and broad scope that we see. They're not necessarily a legal definition, because I'm not sure if there is something like that out there. Again, one more quiz for everyone. If you can find a specific legislation that defines the varying types of statutory legislations, please put it in the comment box as well, so I can learn something from the audience as well. So if you want to look into the example of regulations, we can see, sorry, can you go back to the previous slide, please? So regulations are generally, like I mentioned just now, one of the typical examples that we can use is the Tourism Industry Act, where the requirement to be licensed is stipulated under the primary legislation, but the statutory legislation actually talks about the licensing bit of licensing such activity under the primary legislation. So the example that we have here would be the Companies Commission of Malaysia licensing of secretaries regulations. So as you can see, typically under if you can take a look at the table of content, you can see that it has interpretation. It also has revocation of licenses. So this, like I mentioned, these are the nitty-gritty details that are not typically included in the primary act, but they are included in statutory legislations for better governance and implementation and effectiveness of implementation. So moving on to the next type of statutory legislation. We have rules. So rules are generally a set of principles governing the conduct or procedure within a particular area of activity. So we have, what do I mean by this, right? So rules are typically found for incorporation acts. So statutory bodies in Malaysia are called statutory bodies because they were incorporated pursuant to a primary legislation establishing them. So under each primary legislation for an incorporation act, for example, MPC, they will have like a provision where they set up the committee that will oversee the implementation or that can carry out certain activities or roles and responsibilities provided under the Incorporation Act. So rules are here to actually govern their conduct. So meaning to say, what are the roles and responsibilities of the committee? How often should the committee meet up? Or what is the reporting requirement? So these are all laid out in the rules of that particular statutory body. And if you want to compare it to the private sector, it's something similar to what we have in relation to terms of reference or board charter. So it lays out the provisions as to how the committee should behave and conduct themselves as a body overseeing the statutory body. And so another example that we can also have in relation to rule is we have when it comes to regulating an activity. So here, an example that we use is companies' corporate rescue mechanism in 2018. So if you look into this particular subsidiary legislation, one of the new mechanisms to save companies that is provided under the Companies Act is called corporate rescue mechanism. But these rules are meant to lay out what are the requirements, what are the procedures in relation to actually for you to obtain and use the principle of corporate rescue mechanism to save your company. So this is another example. So like I said, it could either be rules in relation to conduct of people or and authority, as well as it could also be rules in relation to the certain principles and activities under the primary legislation. Can we move on? If we look into the next one, it will be order. And of course, order is the scope is an authoritative command or instruction. And I feel like I may not have to explain much on this because, and this order is the reason why we're doing this webinar instead of doing like a talk and face-to-face basis. Basically, the order that all of us are very familiar with is called the movement control order. So the movement control order is just there to just give a specific instruction for the public to follow. So, and typically the order is supplemented by regulations. So the examples that we have here, we have the movement control order, and we also have the regulations that is issued supplementing, not pursuant to the order, but the regulation is issued under the primary legislation, supplementing the order to include, for example, the list of essential services. So as you can see, whenever they have different intention, so order is meant to give a command. So the regulation is meant to provide clarity to the public. So that's basically how it's easier for you to differentiate what are the purposes of having these varying types of subsidiary legislations. So another type of subsidiary legislation, they are called bylaws. So bylaws are basically subsidiary legislations that are issued by local authorities at the state level. As you all know, that we have three levels of government. We have the federal government, we have the state government, as well as we have the local authorities as the local government for the local authority jurisdiction. So what I mean by this is that the bylaws are, so we have this primary legislation called the Local Government Act 1976. And Local Government Act 1976 empowers local authority to issue their own bylaws in relation to governing activities that is listed in an exhaustive list under the Local Government Act 1976. So it is interesting to see this because if you look into the Local Government Act and if you look into the subsidiary legislations, and this is something that I'll be sharing next week as well in relation to the development, the regulatory development process for bylaws. For federal territories, they're actually issued as federal instruments only because the state authority for federal territories is Kementerian Wilayah Persekutuan. So that is a bit of a teaser of what we'll be talking about next week. But generally, for now, what we must understand in relation to bylaws, these are the type of these are the laws that are passed and issued and made by the local authorities to govern matters that are provided to them under the Local Government Act 1976. So for example, what do we have for bylaws, right? So the Local Government Act allow local authorities to license certain activities such as trade and businesses. So under that provision, it says that local authorities are allowed to pass bylaws. So that is why the local authorities would then issue bylaws in relation to licensing of trade and businesses and other types of activities that is provided. So like I said, this is quite similar to regulation, but at the level of local authorities, because typically bylaws are there to stipulate the nitty-gritty and the details in relation to the licensing, in relation to I don't know, what can you do in public parks, or what can you do in your kawasan perumahan and things like that. Maybe I can give a bit more example later on, but maybe let's just move on to another type of subsidiary legislation. So we also have notification. So notification is a formal declaration and publication of an order and shall have to be in accordance with the declared policies or in the event of the requirement of the legislation. So an example that we have here is the Holidays Act, right? And as you know, that for example, Hari Raya Puasa, it doesn't have a specific date in a year, so it moves from one date to another depending on when you can see the anak bulan and things like that. So for notification, it is easier for the implementation authority to just issue a notification to just declare when exactly do we have public holiday for Hari Raya Puasa. So notification is somewhat quite bulky, but we have a lot of notification because it is just a simple way of notifying the public about something. And also it is important to note that the reason why these notifications are gazetted is because these are provided under the primary legislations. Certain announcement or certain decisions and certain implementation of activities that are done by implementation authority are required to be gazetted. Another example would be under customs, they have crude oil punya legislation. So every single time they want to impose a certain harga, a certain price for the crude oil, they will have to actually notify and gazette a notification to announce the prices. So generally, notification is just to inform the public lah, so to speak. So, and the next one would be proclamation. Yes, so proclamation is an act that formally declares to the general public that the government has acted in a particular way. Typically, it is used in times of emergency. So like I said, Article 150 of the Federal Constitution empowers the YDPA to pass any proclamation, especially in relation to emergency situation. As you can see in the example that we have here. So what about the other types of subsidy legislation? So the other types of subsidy legislation may include resolution, notice, and this includes anything that is made under the authority of the Parent Act, if any. So here we can see this is a notice to third party, and it was issued under Anti-Money Laundering and Terrorism Financing Act. It's just basically to inform that, oh, this is a notice to a certain number of people that this maybe you are required to do this. For AMLA, it's usually maybe a freeze of asset and things like that. So that's generally the varying types of subsidy legislations that we have. So if we move on to the next bit that we'll be speaking on. So let's take a look at the sources of primary legislations. We have laid out to you the Malaysian legal system. We have given you the scope of primary and subsidiary legislations. Now we're going to look into the sources of primary and subsidiary legislations. So here we have the House. I love putting this kind of graphic because it's really easy for us to remember. So here the sources of law that we have in Malaysia is basically we have both written and unwritten law. So for written law, we have all of this list, and we have the federal legislation by the elected parliament, the emergency ordinances, it could be the pre-Merdeka laws, the 13 state constitutions, and what is most important if we want to remember about the sources of written law in Malaysia is that the applicability, the degree of applicability of all of these written laws, it varies based on the provisions provided. So for example, the state constitutions would not be applicable at the federal state. Similarly, the federal legislations would not be applicable at the state level. So now that we've looked into the written law, let's take a look at the unwritten law as well. So we have both legal and non-legal sources for unwritten law. So legal, we have British common law and equity, as well as the precedents of the Malaysian Superior Court. Why do we have this legal authority, but they're unwritten? We mentioned that it is unwritten because it is, it has not been gazetted or passed by any of the legislative authority that we have discussed before, but it is important to use them as a reference point because as much as we have primary legislation that lay out the principle, the general principles of the law, and then we have the subsidy legislations to provide a bit more details for an elaboration for the provisions, but we would still have a little bit of loophole or gap that will always happen. And this is where both parties, when they have a bit of dispute, especially when it comes to businesses, they will go to the court and ask the court to actually pass certain ruling and to make decision. And that will also be binding. And it should always be a matter of consideration. So even for lawyers, it's not enough and sufficient that we only refer to primary and subsidiary legislations. Whenever we want to pass certain opinion, we will always have to rely on the things that we can find under the case law. So moving on to the non-legal unwritten laws that we have in Malaysia, we have the Sharia law, basically how to kahwin and all that, Malay adat.
Sorry to disturb you. I think we are running out of time. If you possibly could expedite your presentations.
Yep. Just very quickly, just give me 5 more minutes. I'm almost done. Please bear with me. Thank you for listening. So going on to the non-legal sources, we have, like I mentioned just now, I just want to bring your attention to the quasi-legislation, and it relates to our next slide. Can we go to the next slide? Okay, so for soft laws, this refers to quasi-legal instruments which do not have any legally binding force, but they are very much persuasive. So these are the very two important examples that we can take a look at. So if you look into this one, the first one, the horizontal, is called the Guideline for the Management of Integrity and Governance Unit. So the guideline is actually issued by SPRM, which requires all JLCs and statutory body to establish and set up governance and integrity unit within the particular organization. As much as SPRM issue this guideline, but it is not enforceable because it is not issued pursuant to a specific provision under the primary legislation. It is in contrast to what we can see for example, circulars and guidelines issued by Bank Negara or issued by SE. Whereas if you look into the source of law, then it will say that this guideline is issued pursuant to Section 54 or Financial Services Act, for example. So that will actually be binding. In contrast to what we have here, the soft laws are not binding, but they are typically used as a reference point, or they're very much persuasive. For example, as much as the guideline for the management and integrity unit are not enforceable, there's no penalty if you do not follow. But what we understand is that if you do not follow, then SPRM will report that you did not follow to the PM. So you'll be answerable to the Prime Minister of the government lah. So the second one, just very quickly, I'm so sorry. So the next one would be, this is our public consultation document on the guideline on short-term residential accommodation. So similarly, the guideline on STRA is not binding and is used as a reference point for regulators to actually issue their own laws. So under this guideline, we have the broad requirements as to what you need to do and comply with to conduct STRA, but the legal instrument enforcing these requirements are meant to be passed and made by the respective local authorities and state government. So this is, like you see, is even though it's not binding, but you still have the degree of persuasiveness in the lawmaking process by other implementation authorities. Okay, can we move on to the, okay, so very quickly, so whatever that we have explained before, let's take a look at the practical application of the theories that we have discussed with you. So if you look into the overview of the Malaysian system, legal system, we have number one, the federal constitution as the supreme law that empowers the parliament to pass legislation, and then the parliament pass the primary legislation. Here we use an example of Companies Act, and the primary legislation delegates the power to an authority to implement the provisions, which include making subsidiary legislation. And here we can see the example of SSM being the authority. And then SSM is empowered to pass subsidiary legislation to supplement the Parent Act. So this is just a very brief overview of the Malaysian legal system. And then I would just want to bring, so for this presentation for part one, this would be the last slide that we have. I just want to bring a bit of your attention to the last slide, which is basically what we'll be talking about next week. So what will be covered next week? We will be looking into the legislative process on 3 levels of government, the parliament and the state, as well as the local authority. We will also be looking into common features of legislation, meaning how do you interpret certain terms that we can find in subsidiary legislations and primary and subsidiary legislations. So and as well as, okay, this is always like the most common question that I get is, what is PUA and PUB? Yes, we will be discussing those things as well. And number 3 is basically if you have specific inquiries in relation to Malaysian legal system and to what we've talked about, please put it in the chat box and we can consider to include them. And inshallah, we'll be able to address your inquiries in the next session. So that's all for me. Thank you very much for listening to me rambling about Malaysian legal system. But I would like to pass this back to Encik Lamin.
Thank you, Leah. Thank you, Leah and Nick. I think it was a great presentation. I think because due to the constraint of time, I think we have a few questions. I will select I think 3 questions, a quick one, and then one is from the attendees. I will open up only one speaker. I mean one attendance to one participant raise the hand. And then first questions from Cik Razlan Mustafa. He asked about is there a section in the law that state that if the YDPA, Yang di-Pertuan Agong, does not sign the approved bill, it will automatically be accepted as a law after a certain time period. Dia or Nick, do you want to?
I can start. So basically, for that question, if the YDPA does not approve, it goes through a process of it has to get royal assent. But even if YDPA does not give the royal assent, after a certain period, about 30 days, that law will be deemed as if the YDPA has given his royal assent. Meaning to say that even if YDPA tak approve, the law will still be effective. So that would be the simple answer. If Nick wants to add, go ahead, or if you think that is sufficient, we can move to other questions.
Okay. All right. No. Then next question from Win O. She already left, but I think a very good question.
Sorry, it was you.
So the question is about, he asked about, for the state law to be passed, do they go through the same legislative process as the parliament?
Okay, so for state laws, they will have to get the approval of, it will be the same process, but it will be in Dewan Undangan Negeri only, so they don't have to bring it to parliament. But the process will be the same, but it's in Dun.
Okay, thank you. Another one, I think I take from Mr. David Yap. Hi, may I know the difference between revision of an act and reprint of an act? Difference between revision of act and reprint of act.
Reprints are just because sebab we have the publication organization that is under the parliament. So reprint is just basically they reprint the new versions. But revision, like I mentioned, if there are any typographical error, grammatical error, then it will be inside the revision act. So the reprint is just macam, you know, a new edition for that particular. It's just in relation to the publication bit, but not so much about amending the substance.
Okay, I think next, I think I give to Cik. He raised a hand. I open up your mic. Cik Anwar can speak. Cik Anwar. Cik Anwar. Cik Khairul Anwar. And Cik Khairul, you can ask the question to the speakers. Cannot? I already unmute. It's okay. So I think we already end of our session, because our webinar session is an hour, a 1 hour session. So we already passed to 11 minutes. So I think that's all. Thank you, both of you. It was a very good presentation, a great presentation. I think we will meet again next week on the part 2, as mentioned by yeah. So for next week, we do also have programs. If you interested, we have on 20th, we have a delivery construction permit works during and post COVID-19 information on 20 April, and also on the 20 April, agro-food supply chain ability to access affordable food effectively and continuously. So also on 20 April, we will email and send the flyers to all the participants. If you are interested on this topic, please join. And also don't forget to register again for part 2 on our understanding of Malaysian regulations. So once again, thank you very much for listening, attending our GRP webinar session, and see you all again. Thank you. Assalamualaikum.
Assalamualaikum. Thank you, everyone.
Thank you, everyone, and stay safe.
Healthy and stay healthy and stay at home.
Oh.